Hello, and welcome to our Compliance 2022 Hot Topics and Predictions for TCPA, Marketing and Privacy. We're so happy that you're joining us today. We only have a half an hour, so we're going to move rather quickly. The first thing you're going to notice is that Helen is not here with me. She got called to an emergency meeting at the last minute, so Josh, who I am eternally grateful for, is filling in for her at the last minute. Welcome, Josh.
Thank you. I can't fill those shoes, but I'll certainly try.
I have no doubt you can. Also, I want everybody to know we are recording this and it will be available on demand after the presentation. You can get that on our website at mslawgroup.com. Also, if you have any questions, please put them in the chat box. We likely are not going to have time to get to them during the presentation, but Josh and I will take a look at those afterwards and we'll make sure that we get back to you and send you a response. We did get a few questions prior to the webinar and we'll try to include those in our presentation as well. So with that, let's get started. First, a disclaimer, while we are lawyers and we will be talking about legal topics, we are not providing legal advice. So if you have any questions about the specific application of the laws we're talking about to your specific factual situations, make sure you consult with an attorney and we are always available to assist with that. So these are our top 5 topics that we're going to be talking about, and let's dive right into it. First, I can guarantee you, and that doesn't happen very often, that the FTC will be in a lot of headlines in 2022. As you probably recall from earlier this year in the AMG capital management case, the FTC lost one of its significant enforcement tools when the Supreme Court ruled that it could not go directly into court in order to get certain types of fines, including consumer restitution, disgorgement, and those types of things. And the FTC being able to threaten going directly to court was a pretty significant club in getting companies to work with them and reach compromises with the FTC for fear that they would have to litigate those cases in court. So as a result, you'll see that the FTC has come up with some creative ways of addressing that even before the end of 2021 going into 2022. Also, the FTC was significantly downsized during the Trump administration. We're seeing that they are already starting to hire again in order to make up for that downsizing. But as we'll talk about here in a moment, the FTC is seeking a significantly larger budget in order to do what they would say would be right sizing again and being able to increase the enforcement abilities of the FTC. One of the ways that the FTC has already started to respond to this loss of power that occurred after the AMG case is that they're using this previously allowed provision, but that had never really been exercised. And it's this concept of the notice of a penalty offense. There's a provision in the FTC's Act that allows them to go after damages if they put a company on notice that they're violating one of the laws that they enforce. And so what the FTC did about a month and a half ago now is they sent out these notice of penalty offenses to approximately 700 of the largest consumer products companies. And they were specifically worried about testimonials and online reviews that these companies were using in their marketing and advertising, and particularly on their websites. And so the FTC said that they believed that these companies may not be complying with the testimonial and guidelines requirements and the legal requirements. And so by putting them on notice, they're saying that they believe they could be violating the law and that they would have the ability to go after them for monetary penalties directly into court. And by doing that, they would be completely skipping the administrative proceeding, which if they can't go directly to court, they have to go through an administrative proceeding that's set up in the FTC first. Also, the FTC is already talking about more rulemaking as they head into 2022. They're previewing some of those rules. Josh is going to talk about that in a minute when he talks about privacy. Also, in 2021, there was a new chair that was appointed to the FTC, Chair Khan, and I will tell you that she primarily has an antitrust background and focus, but she has been speaking an awful lot about privacy, and she has been very proactive in trying to find ways that the FTC can make up for their loss of power through the AMG case. Also, in this executive order on promoting competition in the American economy, that was something that obviously was put out by President Biden. That was earlier this year. But it was talking about what the focus is that he wanted for the FTC going into 2022, which is obviously going to have a significant amount of influence on the FTC. And the main focus in that was privacy, and that the FTC become more proactive in the privacy arena. And so, Josh, I think that's a nice lead in for some of the things that we're going to be talking about. But first, let's cover the rest of the FTC.
Yeah, and so continuing on with what Michele was mentioning, the FTC is definitely seeking to increase enforcement. One of the areas is with eco claims under the green guides. And as we have seen over the last few years, consumers are very interested in using eco-friendly products, green products, organic products. And what a lot of businesses don't realize is there are actually very detailed guidelines from the FTC regarding how you can make those claims and the types of claims that you can make. In fact, I just used one eco-friendly that they say you really shouldn't make because it's too hard to substantiate. So for any business that's using green or environmental claims in their advertising, you definitely want to take a look at those green guides as we head into 2022. Another area of focus is on preventing UDAP. Those are unfair, deceptive, or abusive acts and practices with regard to veterans, service members, and children. These are populations that have always been protected, but with the new FTC leadership, they are going to really step up enforcement in this area. I'm going to skip the bias in algorithms and biometrics for just a moment. We'll talk about that a little bit more in privacy. And then the last item I want to hit on here with FTC is this idea of enforcement against families of companies as opposed to single companies. What we've seen in the past is sometimes the FTC will focus specifically on what a single company has done that it potentially violates the law. They're really going to start looking now at other affiliated companies, ones that have common directors, common officers, or common owners, and take an enterprise theory of violation. So the old model of, well, maybe I can get away with something by tucking it away into this little LLC that I can just shut down and it's not going to be a huge deal, may not work anymore. That's going to be an area of risk. So turning to privacy, this is an area where the FTC is really going to step up enforcement. Here on your screen, you see a couple bills that were proposed in Congress to deal with privacy regulation and to try to establish a national privacy framework, something that many companies believe America sorely needs as we see the rise of state-level privacy regulation. Unfortunately, those bills have not had much traction. There have been significant points of disagreement, particularly around private rights of action and whether the federal law should preempt state laws. And you might be able to guess this, but the way it breaks down is typically Democratic members want the bills to not preempt state laws and they want them to have private rights of action. Republican members are the opposite. And they've yet to be able to marry these divergent viewpoints, even though there is much agreement amongst members of Congress, and you hear this in the press, that privacy and data security are huge issues that need to be addressed. So how this is getting addressed potentially is with a $500 million infusion of cash into the FTC as part of Biden's Build Back Better bill that would allow the FTC to create a dedicated privacy bureau. That bureau would focus on privacy and data security issues, including, as we saw in the last slide, bias in algorithms and biometrics, which is something where, particularly with race, a lot of African American and Latino individuals have found that algorithms and biometrics tend to discriminate because they're trained with primarily Caucasian data sets. And this creates a lot of issues for people who are trying to use those services. Also looking at how to protect children online. You may have heard of the the concern over a children's version of Instagram, which seems to be on hold now because there is real worry that children are getting manipulated online or exploited online in ways that are very, very detrimental for them on the long term. And so the goal of this $500 million infusion is to allow the FTC to have the staff to take their existing UDAP authority and define what sort of privacy and data security practices are unfair or deceptive, and then enforce against those. And we'll see if it passes. We know that negotiations are ongoing with Senator Manchin and Senator Sinema on the bill, and this has already been cut down quite a bit from, it was originally $1 billion to 500 million, but it's still a lot of money. And one of the things that really gives this a lot of legs is Commissioner Bedoya, or I guess hope to be Commissioner Bedoya. He was a law professor nominated by President Biden to fill the last Democratic seat on the FTC. He is a huge privacy advocate. That has been his professional academic interest. People thought he was going to sail right through to the seat, and then some concerns were raised. And earlier this month, at the committee level in the Senate, there was a tie vote on whether to advance him. So he's kind of in limbo at the moment. We'll see what happens, but if he is seated in that last seat, we know who will be driving that privacy regulation from the FTC going forward.
Well-funded privacy regulation
yes,
if this goes through. I will say that, as you know, our law firm is general counsel to PACE, Professional Association for Customer Engagement. So it's the industry trade association that represents contact centers and those that are doing direct consumer engagement and that kind of life cycle of consumer engagement. And so we have been very active with several other associations on these federal and state issues that come up, and we'll continue to do that in 2022. But the U.S. Chamber circulated a letter on Monday, which PACE and I think it ended up being 86 other national trade associations and companies, pretty impressive list of companies that are urging the Senate to remove this provision. And they are claiming it violates something known as the Byrd Rule, which does not allow for these type of funding provisions in these types of bills. So when they're working on the consolidation bill. So we'll see what happens with that. We'll see if that had any effect, but it does make a point that I think is important to make here, and important to make when we have federal and state agencies and administrations that are very proactive, that it's really important to work with trade associations. I'm sure most of you are involved in several of them, to pay attention to the issues as they arise, like the funding bill that's going through right now, and staying active on those types of things. There's some rather large companies that are on this webinar, but any size company, it doesn't matter. It's just really critically important to stay active and to educate your congressional members, both on the federal and the state level.
Yeah, and Michele, just to bounce now. Well, I'm gonna get on your soapbox for just another second.
Then. Go ahead. Yeah.
But one of the other things that letter pointed out, which was a really important but I think underreported piece of the proposed legislation, is that it would empower the FTC to get around the issue you talked about earlier of not being able to go directly into court. It was actually going to tweak the FTC statute to, at least with privacy issues, to allow them to go straight to court. And that was a very underreported potential change that the chamber did pick up on, and I thought it was really wise of them to highlight that in the letter.
Yeah. You know, as we move forward on the privacy issues, Josh has already talked about the state preemption. We have a slide we're going to talk about state privacy laws as well as part of our prediction. But you know, as well as the preemption, there's also this concept of whether there should be a private right of action in these bills, and that, I have to tell you, is a pretty scary concept. as you think about the types of things that can be a violation within these privacy bills that are already starting to pass. But we'll talk about that here in a minute. All right, so wow, I'm going to get that right one of these times. Spinning the wheel on here, Josh. It's back, not forward. So let's talk about number 3, which is that the state AGs are going to be more active. And if you didn't think it was possible, I'm going to tell you that I think it is possible and that we're going to see much more activity at the state AG level. They have become very proficient with sharing information with other states and with federal agencies that are also responsible for enforcing consumer protection and privacy laws. One of the things that I'm sure you've heard us talk about before is the National Association of Attorneys General, in which ENAG, the world's greatest acronym, in which all of the state AGs get together for multiple NAG meetings every year. And as part of those meetings, the state consumer protection chiefs or the head of those consumer protection agencies get together at least twice a year. And there is a public portion, a half a day, that starts with lunch and ends at about 5 o'clock, where the state AGs will preview those issues that they see as most important and those that they will focus their enforcement efforts on. And so if that's something you're interested in staying on top of, you can, those are open to the public, you can attend those meetings. Also, we try to keep folks up to speed and current on those meetings through the blogs that we post on our website, so you can always check for those on there as well. But we know that there is a lot of data sharing now that's going on between those agencies, and also with some of the third-party vendors that we'll talk about here in a minute that are assisting with compliance efforts. Also on the state level, we think that you will see a lot more enforcement of the state's auto renewal laws. So those deal with continuity programs or negative option programs, that when a consumer signs up for a reoccurring service and they're charged on some repeated schedule, usually monthly, and those will auto renew. Some of them are annual auto renewal. But almost all of the states have auto renewal laws that require disclosures, and it depends upon how long that contract is. But for the annual specifically, those you'll need to give notice within a certain period of time, and generally up to 30 days prior to that auto renewal. And there is a attorney general, obviously, cause of action within that, and some of them have private consumer remedies as well. Josh, I know this is something that you've really been on top of for several of our clients. Is there anything you want to add about the auto renewal laws and some of the amendments that we've already seen this year?
Yeah, I would say there are about a dozen states that have these laws with broad application. A number of other states have them specific to certain industries. And what we have seen over the last year is an increase in notice requirements at the time of purchase and pre-renewal reminders. They want to make sure that consumers know at least every so often that these plans are going to renew. And so if you do have one of these continuity plans or these automatic renewing subscriptions, definitely get with counsel to figure out what you need to do to stay on top of those.
Also, we will definitely see more collaboration between the state AGs and the FTC. It's already happening. I predict that we will have a massive sweep, which is what they're called, when the state AGs work in collaboration with the FTC to focus on a specific issue to draw attention to it. And generally, the AG's offices independently will bring lawsuits, causes of action, or at least they'll announce settlements that they've gotten in an area that they want to pay attention to. I think it will most likely be in the lead generation telemarketing space. And the reason I say that is a lot of you who pay attention to our blogs and webinars that we do heard me talking about a meeting that the Michigan and Ohio AG's offices hosted in October, in which they basically talked about the anatomy of a robocall enforcement action. They had representatives from the Department of Justice on, from AG's offices, from law enforcement, from the industry traceback group, which is a group within the trade association that represents telecommunications companies. and is just really briefly, if you're not aware of Industry Traceback Group, they work collaboratively with the regulators to trace back to the origin telephone calls that they believe are being made illegally. And so US Traceback Group was part of that NAG October presentation, the FTC, the FCC, all involved in that. And it seemed pretty obvious from their presentation that they are working together on some type of enforcement action in that area. I've heard rumblings of investigations that are going on right now that will bring a major focus to the lead generation and robocall world. So something to pay attention to. We will see more collaboration in that area. Also, the attorneys general's offices will frequently get together for what they call multi-states. So the attorneys general would decide that there's a company that likely has a presence in all 50 states that is violating one of their consumer protection laws, and so they form as a group to prosecute that company at the same time, instead of the individual AGs bringing their own claims and initiating their own litigation. Really, the AGs, we got very proficient at this during the tobacco lawsuits that were filed, and they've just continued to proliferate since then. And so NAG has put together a multi-state directory, which I think is really interesting. This is open to the public. It's at nag.org, and you can do search for multi-state directory, but it will show you all of the multi-states that the state AGs have cooperated with each other over the really going all the way back to the tobacco litigation and beyond. I encourage you to take a look at it. It's interesting to see what those regulators find as important, and you will most definitely see trends develop in that multi-state. Also, as I mentioned, the Industry Traceback Group, there is a standing subpoena from the FTC, the FCC, and almost all of the state AGs that asks for information about companies that the Industry Traceback Group requests information from. And typically how that happens is that the Industry Traceback Group will become aware of complaints that have been made against a company, and they'll request information. So that complaint about the company and the information they provide is made public to those agencies. And I've already talked about the webinar. All right, Josh, state privacy law, that's where the excitement is right now.
Oh yeah, this is the exciting topic. So just to remind everyone, because I think it's important to keep these in front of you, the California Privacy Rights Act and the Virginia Consumer Data Protection Act both come into effect January 1, 2023. And the Colorado Privacy Act comes into effect on July 1, 2023. So 2022 needs to be a year of looking at your privacy practices and making sure you're getting everything up to speed with those laws if they apply to you. And let me just tell you, that's a big project. Don't wait till October, November of 2022 to start, or you're going to be really behind the ball and you're probably not going to get it done. That is really
Josh,
a year long.
that only takes a week or two, right? Only a week or two.
Yeah, only a week or two. It's going to be a lift. But in terms of new privacy laws, this year, Washington. What's on your screen is my prediction. We'll see if I'm right. I'm usually not a betting man, but I really do think next year Washington State is going to get its privacy law across the finish line. It has come a hair's breadth away the last 2 years from passing. And you can probably guess what the sticking point has been. It's been on private right of action. That's been the sticking point. So I really think they will work out the kinks next year, and we will see that come into effect. And the Massachusetts is currently considering 2 competing privacy bills that are making their way through committee. They've got a lot of traction and momentum behind them, and they are scary. They're very onerous bills. They have private rights of action, onerous regulatory penalties, more akin to GDPR, some really, really tough legislation. I think we will see them in some form pass in 2022. maybe not in the form they're in right now, but just knowing Massachusetts as a very consumer protective state, since these bills have momentum behind them, I think they're coming. The one that may be a bit dead is actually Ohio. Ohio was one that we thought was going to be passed in 2021, but it has now stalled out. Reports are that committee leadership wants more time to study the effects or potential effects of the bill before advancing it. So we'll see if that happens in 2022, but I think we can breathe a sigh of relief on the Ohio bill for 2021. So stay tuned, watch our blogs, watch our webinars. Anytime a state privacy law passes, you know we're going to be shouting it from the rooftops, and we will keep you up to speed.
I think you're right on those predictions. Washington has gotten close a couple of times. I think this will be their year, and Massachusetts sure does seem to be moving quickly. Again, you know, not to be on the soapbox again, but just really critically important to pay attention to these and be involved with the groups that are advocating for fair laws to be implemented. All right. Oops, there we go. And so I think our number one prediction is we're going to continue to see case law develop in the post-Facebook era. And so, as I'm sure most of you on this call recall, on April 1st of this year, there was a decision issued by the Supreme Court in the Facebook versus Ducat case. And what it said was, once and for all, we thought, clarifying within the Telephone Consumer Protection Act what actually qualifies as an automatic telephone dialing system. And the reason that's important is if you're using an automatic telephone dialing system, then you have to have prior, for sales calls, you have to have prior express written consent to make those telephone calls. Or if they're transactional non-marketing calls, then you have to have express consent. That also applies to text messages as well. And so critically important that people be able to understand whether they are or not, companies need to be able to understand whether they are or not using an automatic telephone dialing system when they're making these types of telephone calls. It's been up in the air for a very long time. We started paying a lot of attention to this in 2013 when the TCPA was modified to take away the existing business relationship. That's why you didn't hear much about this prior to 2013. So in the Facebook decision, they basically said that in order for a system to be an ATDS, it must use a random and a sequential number generator to either store or produce telephone numbers. The important point about this is what Facebook was saying is that the numbers have to be generated using a random or a sequential number generator. Now, I think it's that clear. Unfortunately, not all the courts have agreed with me, and there's this infamous footnote 7 that brings in the concept that if you are sequentially dialing telephone numbers from a list, then you are using an ATDS. The good news is there was a case that actually came out today that dealt with this issue. It was another case in the U.S. District Court of California for the Northern District, Cole versus Sierra Pacific Mortgage, that agreed that the Supreme Court held that it must be a system that either randomly or sequentially generates those telephone numbers. So not dialing from a list, but actually randomly or sequentially generating the phone numbers themselves. As you might recall, there was also a decision that came out about 4 or 5 months ago, also in the Northern District of California, which is important because that's where from the Ninth Circuit is where the Ducat case came from. So being in the Northern District of California is important since they're usually one of those courts that are out there. But we got involved in a case called Do Not Pay, Huffness versus Do Not Pay, in which on behalf of PACE, we filed an amicus brief that dealt with this issue, and the court agreed with our position that that footnote 7 about dialing from a list that had, the list itself had been generated in that way, was not an ATDS. So I think we'll continue to see cases in that area. Josh, we have 1 minute. Do you want to say anything about Facebook?
So I do want to say that the trend in the cases is toward recognizing what the Supreme Court said. So
Yeah.
I don't want people on the webinar today to run panicking that they've misunderstood. This is really about knocking back the plaintiffs who are trying to chip away at what the Supreme Court said, and the trend in the cases is definitely towards that narrow position. So I think
sure.
I think this will work itself out. Unfortunately, there will be several companies that'll have to pay quite a bit in legal fees along the way until it's finally worked out. But we're going to get there.
Yeah, yeah, and it's an important point that Josh is making. Where this becomes an issue is that you would think that with cases after the Supreme Court decision, you'd be able to get these cases out early on in the initial pleading stage with a motion to dismiss. Unfortunately, there are some courts that are saying that there's still a little bit of ambiguity, and you have to look at what the dialer itself and have testimony on that before they're willing to make a decision. We're hoping that, as Josh has said, and we think it will be the trend, that more courts, as they look at the Facebook ruling and other district courts that are interpreting it, and circuit courts, that they will agree that it has to be numbers that are actually randomly or sequentially generated from a random or sequential number generator. So if the telephone numbers themselves, not calling telephone numbers from lead lists or customer lists or things of that nature. We have a on-demand webinar that Lisa Messner, the head of our litigation group, has put together. So if you want to hear more about this topic, she spends a half an hour on nothing but Facebook and the claims that have arisen since then and how those are being interpreted by the court. So you can get lots more information from that webinar. Also, as I said, on demand on our website. And then also we thought we'd just leave you with a David Bowie quote here that I don't know where I'm or where we're going, but I promise it's not going to be boring. So with that, happy holidays to everybody. And we look forward to seeing everybody and working with you in 2022. Thanks, Josh, for filling in. I appreciate it.
Thank you, everyone.
All right, take care, guys.